You're listening to an ECGI podcast on corporate power and the politics of change with Matteo Gatti.
I wrote a book about corporate governing, the phenomenon by which corporations have taken actions and positions on contested social and political questions. But I'm often asked, how can they actually do that? Is it legal? Most people who ask that question seem to start from a confident premise, shareholder primacy. As directors have a fiduciary duty to maximize value for shareholders, they cannot divert corporate resources to political or social causes. That's how the theory goes. On the other hand, the stakeholder capitalism camp counters that such conduct is not only legal, but in fact it's what directors should do. Both, I would argue, are overstating the case. So today's conversation is for the most part about the law as it actually is. My guests know the law better than almost anyone. One of them is a strong advocate of shareholder wealth maximization, of the profit motive, in his own words. He has long argued that the purpose of the corporation is to make money for shareholders. This is both what the law requires and what it ought to require. The debate around stakeholder capitalism is not salient at a board level only. Many pro-social actions and statements occur at the management level, and board oversight is implicated. And the other guest today has been documenting what happens when boards fail in their oversight duties. And he's been asking whether ESG commitments, when they go wrong, can generate real legal exposure. Together, they will help us map the actual legal terrain of corporate governing, where the law gives board genuine latitude, where it constrains them, and where the hard cases live. We'll run through some of those hard cases today, law school style, with hypotheticals, what-ifs, all designed to find the edges of the doctrine. I'm Matteo Gatti. This is Corporate Power and the Politics of Change, an ECGI podcast. Stay with us. Welcome to Corporate Power and the Politics of Change, an ECGI podcast. I'm Matteo Gatti, professor of law at Rutgers Law School, research member of the European Corporate Governance Institute, and author of Corporate Power and the Politics of Change, published by Bainbridge University Press. In my book, I document how corporations have been stepping into contested socioeconomic and political spaces, taking actions and positions on guns, climate, voting rights, LGBTQ issues, in ways that look a lot like governmental action. I call it corporate governing. Chapter 3 of my book addresses whether all of this is actually legal. The short answer is mostly yes, and the reason why are more interesting than the conclusion. I wanted to stress test that analysis today with two of the sharpest corporate law minds I know. Steve Bainbridge is the William D. Warren Distinguished Professor of Law at UCLA School of Law. He's the author of several books, including recently The Profit Motive, published by Bainbridge University Press, a strong defense of shareholder wealth maximization in an era of stakeholderist advocacy. A consistent and formidable critic of ESG, Steve knows the doctrine like few others. Roy Shapira is professor of law at Reichman University, a Merotra visiting professor at BU Business, and a leading scholar working at the intersection of corporate law, litigation, and reputational markets. His articles include Mission-Critical ESG and the Scope of Director Oversight Duties, and Conceptualizing Care Model. He's also my co-author on a few projects, including on a joint paper on ideological shareholder litigation that might surface in this conversation. Steve, Roy, welcome. It's great to have you both.
Thank you.
Thank you, Matteo.
Okay, Steve, let me start asking the foundational question. In the profit motive, you argue that shareholder value maximization is the law of the land. And your book complements the positive law analysis with a normative one as well. Shareholder wealth maximization is good, but I want to push on the descriptive claim. You add that it's up to the directors who get there, director primacy, you call it. So what does Delaware law actually say about corporate purpose, and how much discretion does it give boards to consider non-shareholder interests?
Well, back in 1919, the Michigan Supreme Court, not a court admittedly known for corporate law the way Delaware's are, in a case called Dodge versus Ford Motor Company, had said that the purpose of the corporation was shareholder value maximization. And they said director discretion is to be devoted to that end, that directors have discretion about how to achieve that end. They don't have discretion about changing that end. And Delaware law is consistent with that. There was a leading case involving Craigslist about 10, 15 years ago now, in which the Delaware court explained that having chosen to be a for-profit corporation, the directors and controlling shareholders of Craigslist had a duty to the other shareholders of the company to put value maximization at the forefront of their decision making. Now, having said that, and we can talk about this more, I think is your plan. The fact that directors have a lot of discretion means that the courts have rarely stepped in and said, number one, you've abused that discretion and you are pursuing improper ends of the corporation. You've departed from shareholder value maximization. And there's really only two settings in which the law has teeth. But for lawyers, that's not an unfamiliar concept because the law often distinguishes between what we call standards of conduct and standards of review. The standard of conduct is what you're expected to do, but you're only going to be held liable if you breach the standard of review. And this is an example of that at work, that shareholder value maximization is the standard of conduct, but the standard of review is usually something called the business judgment rule.
Okay, so if we accept shareholder wealth maximization as the standard of conduct, the standard of review, the business judgment rule, ends up doing a lot of work in practice, right? Because as you anticipated, courts will rarely second guess a board decision that has a rational business justification. So to bring it to what we're trying to cover here, a board that cites reputational benefits, employee morale, consumer preferences, or in general, long-term risk management can almost always find some cover for, let's say, a pro-social or ESG flavored decision. And so how much of the shareholder maximization norm survives the business judgment rule?
Well, I think that's an interesting way of putting it. It's not so much that the business judgment rule does away with the shareholder value maximization norm. What the business judgment rule basically is an abstention doctrine. What it says is that unless certain preconditions are not satisfied, such as there's self-dealing, there's a conflict of interest, there's fraud, there's illegality, that the court will simply not review the merits of the board's decision. So as you say, a board that says, well, we think that long-term shareholder value is going to be maximized if we take good care of our employees and we take good care of the environment and so on. A court's not going to second guess that decision. And there really are two situations in which the business judgment rule would not apply. One is what is known as confessional cases, like the Craigslist case, where the directors just said, we didn't care about shareholder value maximization. We're just going to go ahead and, create a community based on classified ads that seem to have mostly to do with sex. And the other context is in takeover settings where the company's for sale. The business judgment rule doesn't apply. Now, none of that should surprise us, though. The business judgment rule is probably the central doctrine of corporate law. It is a principal rule that applies in virtually every situation where there is not some sort of egregious self-dealing or illegality. So the fact that the business judgment rule prevents courts from reviewing the reasons the board has for decisions that may seem to favor corporate stakeholders is no different than the fact that the business judgment rule protects virtually all board decisions.
Let me geographically zoom out for a second. Let's step out of Delaware because that was the dominant jurisdiction, at least for now. We'll see what's going to happen soon. But a bunch of other states have so-called constituency statutes. Those are provisions that permit boards to consider the interests of other constituencies, employees, communities, suppliers, and so forth. So if we're including these jurisdictions, is the shareholder wealth maximization less of a universal rule in America, or it's pretty much the same?
Well, that's a very good question, and that's a long-standing debate over whether these constituency statutes mean anything in the real world. There is virtually no case law out there interpreting these statutes. One of the reasons that Delaware is the dominant jurisdiction of American corporate law is that Delaware has a lot of cases and a lot of case law. In other states like California, there's remarkably little case law in our field. And I did a survey a number of years ago on how often these statutes have been applied, and the answer is almost never. There's less than 40 cases that have been decided under these statutes. None of the cases really clearly spell out how these statutes work, what they do, how they change the shareholder value maximization norm. So the answer is they're out there, they're on the books, but they just don't seem to do much.
And probably, if I might add, they won't be doing too much in the non-takeover cases, right? Maybe they do something in takeover cases where directors can take something else into account and cite it, and they don't have to tie it to shareholder value necessarily. But in the field that we're trying to cover here today, which is corporate political engagement, I think under both scenarios, the result will be similar. Which way you pick it, the judiciary will not review the decision of the managers or of the board of directors. So I want to start complicating the discussion here because not all what I call corporate governing is the same. We have some are bread and butter decisions, right? Corporate policies, initiatives, really corporate actions versus some other look like genuine political advocacy, where you have this phenomenon of CEO activism, as our friends in economics tend to define them. So I want to sort of try to stretch this by going into some hypotheses. Some are real world hypotheses and some are, sort of borrow from real world. So one is I cover in the book. I call it a paradigm case of what I call government substitution, which means that state action cannot go in certain direction. In this case, with gun control initiatives, but corporations are not subject to the Second Amendment can set up policies, right? And after the Parkland shooting in 2018, the board of Dick's Sporting Goods voted to halt sales of assault-style rifles, to remove high-capacity magazines from its stores permanently. Is the minimum purchase age for all firearms to 21. So, these are all stricter than what federal law and most state laws require. It turned out that that destroyed, and then also they destroyed $5 million worth of inventory, right? So sales in those product line obviously dropped a lot, and the board knew that this was going to happen. And is this an easy case? Does this sit comfortably within the business judgment rule, or there's a deliberate profit sacrifice that complicates the analysis? And I'm asking you because of what we just covered and what your position is in your book.
Yeah, I don't have any problem with what the board did there. That the board could very well have made a decision. Look, we sell a lot of sporting equipment to little league teams, soccer teams. We work in parts of the country where, people are much more likely to come into our store and buy, a softball or a football or a soccer ball for their children. And, these school mass shootings really scare those folks. And, we will lose some sales because of our decision about whether or not to sell firearm related materials, but we will pick up sales that somebody like Walmart that's going to keep selling guns might lose. I think the board made a perfectly rational decision about the long-term profitability of the company. I think a perfectly common business judgment. There's nothing that goes more to the core of what boards of directors do than deciding what a corporation's products are going to be. So, that's classic business judgment. And it's the sort of thing that gets sorted out in shareholder meetings. Shareholders have an option. If they don't like the decision the board made, they can vote the directors out of office. So I think that's easy case for saying that the business judgment rule should apply. And it was a case that was not like the Craigslist case where the board of directors simply said, we hate guns and we don't care that 90% of our people, our customer base loves guns. We're just going to stop doing it. That was a very different scenario.
Yeah, and that is actually, what you just said is reflected in some empirical studies we have on the podcast, Swarnodeep Homroy, who co-authored a piece a few years ago that found exactly this, that given the polarization of the country, certain statements affect certain force in a way, and affect, so you have a net gain, you have a higher sales in some parts of the country, lower sales in others. The average was that it was beneficial, but to your point, the directors don't even, have to operate under that, because they, so long as it's rational, so long as they're reasonably informed, it's their prerogative to make this judgment call. So I'm going to add another hypothesis here. I'm going to bring Roy also to chime in. So let's assume we have a CEO who uses the corporate platform, sort of speaks as the CEO, so deploys a brand to take a personal position on a contested political question. So it's not a product decision, not hiring policy, but a statement. Let's say that our company believes, A, B, and C about voting rights, or that we oppose this litigation, and, boycotts ensue. So where does that land? Is the board protected if it authorizes it, or what if it doesn't? This is just a CEO move. Roy, do you want to start with this, and then we're going to take it to Steve?
Yeah, so I would emphasize the distinction that you just made in your last sentence, meaning the distinction between board authorized political speech, the way you want to call it, and CEOs going on political rants with zero board oversight. The former category, board authorized political speech, I think it receives kind of the presumption of validity that you and Steve just talked about for the last few minutes. Because it goes back to what you mentioned, what Steve mentioned. It's easy to tie such speech to a business rationale, a consumer sentiment, employee morale, kind of a long-term thinking about the company and its strategic positioning or whatever. And by contrast, if the CEO is engaging in a political speech that alienates some stakeholders without any oversight of the board, that could raise the issue of oversight liability, so-called Kermark liability. We're in Kermark territory. And now there is a path to director liability. It's admittedly a very narrow path. So the court will not expect the board to monitor and prevent every social media post, but I can envision a few unique factual scenarios where the court is telling directors, listen, you didn't take your oversight duties seriously, and it ended up costing the company dearly. So it depends on the facts.
Right. And arguably, what we've been witnessing more recently is the opposite case, right? Because these hypotheses sort of used the old 2016 through 2024 paradigm of CEOs talking liberal, right? But, we've been seeing, Elon Musk making statements quite incendiary at times in the opposite direction. And so the question again is, what happens that I want to go back to, actually, I want to ask Steve if he has anything to add, but then I want to go get into the Kermark territory right after.
No, I thought Roy was absolutely right.
Okay, so let's move on to Kermark then. So how much latitude do boards have when they engage in this? And what liability do boards face if they fail to oversee and manage oversight risks, including ESG risks, right? So as you guys know way better than me, in Delaware, Kermark and its progeny established that boards have an oversight duty, a duty to implement monitoring systems for material risks to the corporation. For most of the Kermark's history, that meant legal compliance and financial controls. Recently, Delaware courts have been expanding it with food safety, opioid distribution, workplace safety. And so the question is whether ESG risks can trigger Kermark liability when boards fail to monitor. So, Roy, you wrote in these field. Of course, Steve, you also have opinions here, so I'd like to talk about this. So is there any coherent theory under which a board could face caremark liability for failure to oversee ESG-related risks?
So, yes, there is a coherent theory, I think, and it hinges on whether the specific ESG issue that you're talking about is critical to the company's success. So, to take a step back, so the board is the organ in charge of risk oversight in a company. So accordingly, if a company suffers financial and reputational harms due to failure to address a critical ESG risk, shareholders can, on paper, sue the directors on behalf of the company, sue them for not being attentive to an issue that caused the company harm. The caremark doctrine, the oversight duty doctrine, is about ensuring that corporate boards take their risk oversight role seriously, take it proactively, and it matters less how a risk materializes, so whether it's through legal sanctions or reputational fallout. Actually, Steve made this point many years ago, many years before I did, back when I was in law school. So what matters more is whether a risk is critical to the company's operation. So in other words, even if a certain corporate behavior, a certain concern is not punishable by law, if it poses an existential threat to the company's reputation and profitability, a board that ignores such an issue does so at its company's peril. So for our purposes here in this podcast, the key question is, how do we know whether a certain ESG issue is critical or not? And to answer that, you need to break down the acronym, break down the ESG into its separate components. It's kind of tempting to assume that all ESG issues matter and affect the company's reputation. But in reality, very few do. Very few ESG issues are critical to the company's core business model. And so very few are subject to a realistic caremark liability threat. Just to generalize, issues that fall within the G part of ESG, like cyber, you have a more realistic caremark threat. Issues that fall within the E, like climate change, environmental, they present a much lower risk of caremark liability, if only because establishing a direct causal link between boarding attention to some climate policy issues and a corporate financial trauma is kind of incredibly difficult. So to illustrate, to go back to your hypothetical, so think about an example where a company is plagued by systemic sexual misconduct. And the board receives clear internal reports of it, but they choose to bury the information or simply protect the company's short-term image rather than addressing the issue. So this could count under existing law as a failure to address red flags claim against the board. And in this framework, the political risks of the kind that you've been writing about and discussing with us here, they do not easily trigger oversight liability because they are more transient risks. They are less easy to anticipate. I'm not saying that they will never give rise to oversight liability. I'm just saying that it will take a unique set of facts to do so.
Yeah, so I agree on that point. And I want to bring in Steve because you have a very interesting position here. Because as a whole, Steve, you've been criticizing caremark. You're not a big fan of caremark on a normative standpoint. But then you look at how it got applied, especially talking about the Citigroup case, and you're unsatisfied, right? Because in that case, the allegation was that the board failed to monitor management who kept buying toxic assets before the financial crisis because they thought they were smarter than anybody else. They were timed their exit right, and in the meantime, they would make money. Of course, they did not have real controls there. Their exposure was massive. And so when the Chancery Court analyzed that case, they said, well, yes, those risk controls were poor, but it was indirectly an assumption of risk. So they draw a line between what's legal compliance, right? So if you violate the law and you do not have control system in place to spot the compliance failure, we got a caremark problem. But if it's just about business risk, then that should not worry us. And you're critical of this, but this example is important. The Citigroup case is important because for political engagement, that's exactly it, right? If I am an executive and I go on social media and I say something completely outrageous, right, that antagonizes me with everyone, right, chances are that I'm not breaching any actual law, especially in the United States when free speech rights are paramount, right? And so the question is, it's one of monitoring business risk. We have a CEO who's a loose cannon and we didn't know how to handle. Under, the Citigroup line of cases, this should not be a caremark punishable, a caremark liability generating fact pattern. But from a normative standpoint, at least, probably even doctrinally, you criticize this distinction, this dichotomy.
Yeah, well, I think one of the fundamental problems with Caremark is that its amorphous outer boundaries, and I think the point you raise is exactly right, that in the Citigroup case, Chancellor Chandler recognized that if Caremark extended beyond this sort of narrow accounting compliance issues and law compliance issues into like risk management issues, imagine the following scenario where a board of directors says, well, some people think we should have risk controls to deal with issue X, but we're perfectly happy to take risks in that area. We don't want to control risks in that area. We want to take them. It's a basic reality of corporate governance that shareholders come last. Everybody else has to get paid before the shareholders do. The shareholders hold a residual claim on the company. And shareholders know that risk and return are balanced, that if you want a higher return, you have to take more risk. And so it's in the shareholders' incentive. And in fact, one of the purposes of the business judgment rule is to allow directors to take risk without having to worry about being second guessed. And that was the concern that Chandler had. But at the same time, how do you separate out risks that shouldn't give rise to Caremark liability from those that should? And part of the problem, I think, that we have at the moment is I think there's an emerging split on the Delaware Chancery Court between, on the one hand, Chancellor McCormick and Vice Chancellor Laster, who I think have been fairly expansive in their interpretations of Caremark, versus people like Vice Chancellor Will, who have been much more conservative. You know, there's a recent opinion out of Vice Chancellor Will's chambers reaffirming that Caremark is supposed to be the most difficult theory on which a plaintiff can succeed in corporate law. And so we're in a state of flux, I think, in this area. And I think it's very helpful to raise these issues as you're doing, because, I think the direction the law is going to take in the next few years is going to be very important in defining what the outer boundaries of Caremark are.
And for benefit of our listeners who are not lawyers, Caremark is a Delaware doctrine. And so in an era of Dexit, right, where, Delaware is trying to maintain its strategic foothold in corporations, Caremark is one outlier case where in Nevada and Texas could have good selling points to say, well, you're not going to be, if you incorporate here, you're not going to be deposed on your failure to oversight. So something else to keep in mind. I want to keep going with the hypothesis, and I want to bring in some complications. So I'm going to have one example of religion, freedom, and profit sacrifice. So the CEO of a publicly traded national pharmacy announces that the company will no longer stock emergency contraception, citing the founding family's sincere religious convictions. And the board approves unanimously, and sales drop measurably in urban markets. And I want to ask this question to Steve with sort of a what if the founding family still controls 51% of the vote, whether that changes your analysis under the business judgment rule or not.
No, I think that the controlling shareholder issue, if you're talking about a publicly traded company, I go back to the Craigslist decision where the court said, if you choose to be a for-profit company, then certain responsibilities come with that. And one of those is shareholder value maximization. There are alternatives. The company could have remained closely held. They could have been like Hobby Lobby, the company that was involved in the Supreme Court decision over birth control issues and abortion issues. They could have chosen to be a public benefit corporation. They had alternatives, but having opted to go public as a for-profit corporation, they have obligations. And if the company simply said, we're going to lose money because of this, and we don't care, then I think they've got a, Craigslist Dodge confessional case problem.
That's interesting. It's because the one example that comes to mind is Chick-fil-A in a way, but which is famously closed on Sundays, right? And so you could argue that, you do the math, Sundays is kind of an important day because families are out. So that's a, big revenue drop. But at the same time, they've always been, very open to what they stand for. And yes, there's probably a potential loss of revenue there. But the question is, how much revenue would they lose if they were to all of a sudden do a flip-flop over this and open on Sundays, get that revenue, and maybe lose some of the consumer base that was going there because also they were endorsing those values. So this is a big counterfactual that we'll never know. It's slightly different in the hypothesis than a pharmacy chain that is there to just put products on the shelf.
Yeah, I think the Chick-fil-A case is more akin to, there's a wonderful old case called Schlensky versus Wrigley, where Schlensky was a minority shareholder in the corporation that then owned the Chicago Cubs. And P.K. Wrigley, who was the majority shareholder, famously believed that baseball should be played in the daytime. And Schlensky said, well, if we installed lights and we played games during the week at night, our attendance would go up and our profit would go up. And Wrigley said, I don't care. And the court said, basically, it's up to the board of directors to decide whether they want to play baseball at night or during the daytime. And it's not up for us to turn their decision around. The Chick-fil-A case looks a lot more like that than your original hypothetical does.
I think you're right. So I want to ask a question to Roy. So with a couple of hypotheticals. So we have imagine a mid-sized logistics company that announces it will not require COVID vaccines for drivers despite a federal contractor mandate, and they cite that it's because of employee freedom. They loses a lucrative federal contract as a direct result, and board had a memo that saying, well, compliance was required in order to keep the contract. So that's the first hypothetical. And the second hypothetical is assume a consumer goods company that pulls all advertising from a media platform after its algorithm amplifies content that the CEO condemns as proto-fascist, right? And so there's a revenue impact that is documented in this case. Do you think that the law treats these two hypotheticals same way?
No, I think that the law doesn't treat them identically. I think that Hypo A, the vaccine mandate hypothetical, presents a severe risk of corporate law liability to the board. And I think that Hypo B, putting advertising money is likely to be protected. So in scenario A of the vaccine mandate, board is basically making a conscious decision to violate a federal regulatory mandate. And you already told us that we have smoking gun evidence that they knew about it. We have the legal memo explicitly outlining the requirement. They knew about it. They opted to flout it. So this is kind of in the line of cases, speaking of Delaware precedent, this is kind of the Massey case. Board can't make a knowing business decision to profit off of skirting regulation of something like that. So that's a classic liability risk for them. In scenario B, pulling advertising, the advertising boycott, it sounds to me more like the example that you've been discussing with Steve earlier of what you call in the book like corporate socioeconomic advocacy or whatever it is, whereby the board decision can be easily construed as a choice to protect long-term positioning, long-term brand, and so on and so forth, like in the Simeon versus Disney case and the controversy over the Don't Say Gay bill. The federal courts basically recognize that boards are fully empowered to direct the corporation's voice on matter of social significance.
So thank you for these great doctrinal analysis. And so I think we're sort of, all three of us agree with what the law says, and kind of glad to realize now that I didn't screw up anything in my book. But these corporations being active in politics is very controversial still, right? So maybe the law doesn't intervene, but we have a big governance problem right there. And so I want to ask you, is there anything we should think as policy fixes, or using, wearing our corporate lawyer's hat and, imagine the board of directors of a corporation seeks our advice and say, well, we're navigating this potentially contentious area. What should we do? What are the steps to do? So there's anything that you want to add there? So is there any policy change that we need, or is there anything that the board should be looking at? Steve, do you wanna start?
Well, thanks. And I think your book really raises those issues in a very profound and helpful way. Um, I'm not convinced that we should be making significant changes in this area yet. There are, in a highly polarized moment in the country, inevitably going to be politicalization, if that's the right word, of virtually everything. And companies are simply not going to be able to avoid navigating in this space. And to the extent that they're doing that with, the shareholder plaintiff attorneys bar looking over their shoulder, I think that's generally not helpful. I think that corporate law has plenty to do without getting into board decisions about how to navigate the political environment. And I think there's plenty of precedent for corporate law to basically say, look, we're going to leave this to the boards to sort out. One of the problems we have as legal academics is that our professional training and our incentive structure is identify a problem and then propose a reform that will fix it. But there are times in this world where it's better to look at a problem and say, let's let business people sort out how they want to handle this and leave policy sort of ambivalent, or at least leave an unregulated space for them to work this out in. And that's kind of where I am on this question of corporate political involvement.
Roy?
Yeah, so I think your question raises two issues. One is, should we change the law? What the law is there a match between what the law ought to be? And the second one is kind of practical implications for corporate decision makers. So I'll try to condense it kind of those under those two categories. When it comes to policy implications, I think that, yes, what the law does is what the law ought to do in terms of not second guessing like board calculated decision. The law is where it ought to be. There's no benchmark for courts to really assess those decisions. So thinking about some of the examples that you use in the book, like Nike and Kaepernick versus Gillette, some of them will prove successful to the company, some of them won't. Every company has its own situation, so it's not for courts to interfere in. When it comes to failure of oversight claims, I think this is the first time I'm maybe disagreeing with Steve. He had this article called Don't Compound the Kermar Case by Extending it to ESG. So I think I disagree with Steve on the starting point, but I agree with Steve on the direction, meaning on the relative part of the argument. I don't think that Kermar in itself, oversight duties, is a mistake, but I do agree that the disadvantages of these doctrines and applying it are bigger in ESG type risks and cases than they are in cases of clear illegality. So it should be more narrow there. And ultimately, I think that, like Steve, these issues are kind of issues of strategy and reputation management, not issues that for the corporate law to interfere with. I would just add, just because you teased it in your opening, that these are interconnected in a sense that corporate law and corporate law litigation, especially in Delaware, has always shaped behavior, not necessarily through imposing sanctions at the end of the trial, but rather indirectly for shaping the norms and reputations in the business community. This is like the famous Ed Rock article on the saints and sinners approach to Delaware litigation. And so in this mutual project of us that you teased on the ideological shareholder litigation, we look at all those cases from the last few years where those plaintiffs have been marshaling corporate and securities law claims to contest companies' engagement with social and political issues, like the Simeon versus Disney example or the Starbucks example. And usually corporate law scholars and business journalists, they often brush aside these lawsuits as completely incompatible. What do these crazy people want to do? Why do they bring these corporate law claims? But the way to measure the successes or the efficacy of such lawsuits is not by keeping kind of a ledger of legal wins and legal losses. Of course, they're going to lose. The success is kind of a function of their ability to reshape, sorry for using this word in a ECGI podcast, discourse in and around corporate boardrooms, maybe changing law firm memos, law firms starting to circulate memos to the clients on what you need to discuss, what you don't need to discuss in boardrooms, maybe shaping media coverage, content, the volume of business media coverage. And this is where the effect of corporate law litigation will be on the issues that you discuss of kind of corporate political activity. So that's on the policy issue. Maybe one more sentence on the practical implications that you asked us to opine on. Maybe just one word, and that is document. If I'll have to recommend one thing for directors with those cases is document what you're doing. Legal advisors, they typically like to keep board minutes minimalistic, kind of a bullet point style, not to give away too much information. But when we discuss failure of oversight claims, impairment claims, it is usually the defendants who have to show something, who have to show that they did something. And as long as you have a good record that you tried, simply tried, heard information, followed up on it, and so on and so forth, that's enough to get you off the hook.
Yeah, and I would just add, simply because I wrote a book about it and I want to say it, so maybe what the takeaway here is that don't have to be too afraid of plaintiffs, right? But, we have to deal with our stakeholders, and consumers can be unforgiving. Your workforce can walk out. Shareholders, we don't know, but some of them will be unhappy. And so, there are ways to be a little bit more transparent about if, how, and when you're going to intervene in the political arena, right? I looked at corporate disclosures at a certain period of time to see what was the coverage of ESG goals was, and virtually all companies of the S&P 100 had ESG goals laid out in their disclosure, SEC disclosure, or shadow governance disclosures, right? And the only one that didn't was Berkshire, because they had all their portfolio companies that did it. So, it didn't really count as a no. But then when it comes to, so these were the goals, right? What we care about. But then only a third of these companies, roughly, were also transparent about how they would engage discussing politically these issues, versus others that say, yes, we're pro employee communities, et cetera, but they would not be transparent about the if and when. Now, the counter argument to that is that probably the consumer, the median American consumer, doesn't really need the shadow governance documents. So, who cares if they are in the corporate disclosures? But I guess that one of the things that emerges from the empirical evidence is that stakeholders want some consistency, right? They don't want to see you as a bandwagoner. They're like, oh, now there's this new political fad and we're all trying to pretend to say X, Y, and Z. And so here comes the consumer goods company that says that same thing. And, we have examples like PepsiCo, for instance. Roy, you mentioned Procter & Gamble doing the Gillette campaign that failed flatly, right? Those are the things that you should not be doing. So I guess you have to document, you have to be transparent, and you have to show some consistency throughout. I want to thank you both for these very engaging conversation. I really enjoyed this. I learned a lot. We keep learning a lot when we talk to each other. So thank you, Steve and Roy, for being here.
Thank you very much.
So the works we discussed today are linked in the show notes. The Profit Motive by Steve Bainbridge is published by Cambridge University Press. My book, Corporate Power and the Politics of Change, is also published by Cambridge University Press. All other episodes in the series are available on the ECGI website and wherever you listen to podcasts, including YouTube. Thank you for listening.